For me to be able to grant you your waiver, which the law requires me to go, the law requires me to favor somewhat against it, I have to go through these special questions. And you and I did not fully get that opportunity last time. So now I'm doing it today for the record, so therefore I can grant your request to represent yourself. If negotiations continue, any negotiations the prosecutor has would have to be with you. Do you understand?
Yes.
Now, that doesn't mean you have a right to have a negotiation, for instance, a reduced charge or otherwise, but any negotiations would be with you. The only caution that I have here for you on that is certain things that if you were to make any statement to the prosecutor that could be considered an admission, that possibly could be used against you. Do you understand?
Yes, sir.
All right, thank you. Next. If you are permitted to represent yourself, hold on. You would be held to the same standard as an attorney. Specifically, that means you would still have to comply with all state laws, the Michigan court rules, and the Michigan rules of evidence. Do you understand?
Yes, sir.
Okay. The reason why I have to highlight that particular statement is that often defendants in your position or a position to represent themselves often want to say, well, listen, I'm not an attorney. How am I supposed to know those rules? I just want to make sure you understand that you'll still be held to those same court rules and rules of evidence, which you have said you understood. Next. All right, good enough. And again, we're just merely checking off the block more thoroughly today without Mr. Harrison here now that he's been removed from the case. The next thing here is at a trial, you have the right to be tried by a jury, the right to be tried without a jury, if you chose and the court and prosecutor consented, the right to be presumed innocent until proven guilty, the right to have next. If you changed your mind, potentially hire an attorney. At this moment in time, you have not yet hired one. That's a fair statement.
With an attorney, we've got to go all the way back to the preliminary examination and try to fix what was damaged there. Going forward, we're at disadvantage because of what I feel was ineffective assistance. I feel I was entitled to a fair shot at the actual apple in the district court and didn't get it, and now I'm sitting here with this little bit of nothing.
Okay, so hold on, Mr. Burnson. I remember this got us off track last time where you wanted to argue about certain things, and I appreciate that you might. Let's try to focus just on my questions first. So the question again was, have you retained an attorney? And so far you have not retained an attorney.
No, sir.
Have you spoken with anyone else, or has anyone else from the public defender's office spoken to you about them representing you?
I think someone tried to call here, and then they sent some investigator here named RJ or something, and he's not even an attorney. He came yesterday for a few minutes and left.
Okay, so let me.
So I haven't been able to consult with an attorney.
Well, hold on. Let me ask the next question. Do you wish to? Because I appointed another attorney last time. I said the public defender's office would represent you. And you filed something you entitled notice of appearance, saying that you wanted to represent yourself. Is that still true? You want to represent yourself?
I filed an application leave to appeal the Court of Appeals over it. Yes.
So the answer is yes or no, Mr. Burns. Yes or no?
Yes.
All right, there we go. That's what we're trying to do. As I mentioned, we had some difficult conversation last time on a busy day. I focused on terminating Mr. Harrison and granting that motion. Before the court can grant the rest of the motion, which means a complete waiver, I must allow you the opportunity to consult with retained counsel or appointed counsel. You've told me that you haven't retained an attorney, and you've told me that you wish to represent yourself and you don't want appointed counsel. Is that correct? You do not want me to appoint another counsel?
May I clarify? I mean, what I'm saying is, I'm not going to establish a relationship that has to be separated if I can consult with an attorney about, the things that I got in my mind. That would be fine. But I don't want to have to come back in and say, oh, I want to get rid of this lawyer because they're busy. I understand. They don't have time for this, and we're. I haven't been able to consult with an attorney, and I don't want to establish a relationship that has to be severed by the court. If I choose to go forward, then I choose to go forward. I haven't been able to consult with an attorney, say, hey, this is what's bothering me. This is, to try to help me kind of marshal the facts, kind of, help me make sure that, I'm in the right vein, going in the right direction, on the right trajectory here. I feel that this is pretty much all pretrial motions. This is pretty much a case of
Mr. Burns, I'm not, hold on. This is very, very simple.
Yes.
In the last 3 weeks, I have allowed you the opportunity to either consult with a retained attorney, which you haven't gotten a retained attorney, and I have allowed you the opportunity to have appointed counsel. But you rejected the appointed counsel and filed your own appearance 2 or 3 days after that last court date. So all I want to know is,
Your Honor, I filed 4 or 5 motions that were sent back to me. So since the preliminary hearing, other than the ineffective assistance of counsel, I haven't been able to get on the record at all.
Hold on one moment.
And when you did appoint counsel, I just heard from him yesterday, and that was a couple of weeks ago.
Hold on one moment, Mr.
Motions all this time.
Hold on, Mr. Burns. Yes, Madam Clerk?
The last time we were here on September 8th, I brought the motions up for that hearing.
Yes.
It was determined that Mr. Burns was going to have appointed counsel.
Yes.
And you instructed me to return those motions to Mr. Burns to discuss with his new appointed counsel.
Okay. Mr. Burns, when you file, or any party files a motion, they file it with the clerk's office. They also contact the court's office and get a hearing date. We do not have a hearing date. File a motion. So I have to go back to the original question. The question was, do you want another attorney appointed to assist you? No. All right, that's it. That's all I needed. That one answer was all I needed. Next. The court finds that it has complied with Michigan Court Rule 6.005. The court has advised the defendant of the charges, the maximum punishment, any mandatory minimums, of which there are none, and risks involved with self-representation. The court has also allowed the defendant the opportunity to consult with a retained attorney. It appears that he has neither consulted with nor hired another retained attorney. The court has also appointed new counsel, but the defendant filed his own appearance and has stated unequivocally today that he does not want additional appointed counsel with whom to consult.
Your Honor,
So, yes, sir?
I was under the impression that I couldn't file anything. You sent it back to me. I had no reason to believe that I could file a motion after you ordered me to take appointed counsel, and appointed counsel never came up here to see me. So in either hand, I could not proceed forward. I went to the Court of Appeals. If we're gonna get it on the record, let's get it straight. I don't have the impression that I'm free to file motions, and I don't want to file them and have them sent back to me if the clerk's not gonna file.
If you don't file them
I asked you what day the motion day was, and I noticed all the motions. I would notice each one 7 days after the day of the nearest motion day. I know how to file a motion, and I know how to notice it. I wanted them to at least be received by the clerk, so that in the event that we were going to go forward, I was going to, there at some point, we got pretrial motions that haven't been done, and was certainly not done in the district court. I've asked for a remand, or at least let's get the Ginter hearing going so that we can go back and start there. I feel that's the only way that we're going to be able to get the prejudice fixed that's already involved in the case.
All right, so let's go ahead and break down the myriad of things you just mentioned.
Okay.
Number one, the court appointed an attorney to assist you. 3 days later, you informed the court that you didn't want that attorney by filing your own appearance to appear without counsel. Is that correct?
Never even met an attorney. I don't know what you mean. The
Mr. Burns.
Yes.
Mr. Burns. But we have already addressed that because you've told me you do not want counsel appointed. Is that correct?
Is this Taekwondo here or what? I've stated under the circumstances how that happened.
No.
How that happened. No.
Do you?
I wanted to. If there was an attorney that I was able to consult with, I would have consulted with him. There has been no attorney for me to consult with other than Harrison, and Harrison wasn't consulting. He was doing whatever he was doing with the sniffles or whatever. Yeah, no, I didn't have an attorney to consult.
Mr. Burns, stop talking. Pay attention. The question's very simple. And I've asked it.
The answer's very simple.
Stop talking, Mr. Burns. If you interrupt me one more time, I will hold you in contempt, which means if I sentence you, if you were to ever get sentenced on this case, you will not get credit in that sentence for the time you're serving for contempt. Do not talk when I'm talking. Now, the question I have for you is, do you want an attorney to assist you? Yes or no?
To assist me in what fashion?
Represent you in a criminal case in a criminal courtroom here in Wexford County.
As a lead counsel.
Do you want counsel at all? You've said yes and no, back and forth.
No, I said if you have an assistant that can assist me in complying with the court rules, that's because of what down at the jail here, I don't have all the access to the materials. If that's the case, fine.
Okay, that's different than what you've said. So
how is it different than what I've said?
It is, because you've also told me you're somehow appealing in the appellate court for me appointing an attorney, but now you just told me you want me to appoint an attorney to consult with. Which one is it that you want? Do you want an attorney to... Do not interrupt me. I hold you in contempt. I'm adding 20 days to your sentence. I've warned you twice. That means if you ever get sentenced on this case, you do not get credit for these next 20 days. Done. Now, pay attention very, very clearly. It's a very, very simple question. Do you want an attorney to assist you or to consult with? Yes or no?
Stand on the record.
But the record's unclear. It's an unequivocal statement, which means I can't let you represent yourself if you make an equivocal statement. I need you to answer the question. Do you want an attorney appointed to consult with or work with in some degree? You are directed to answer.
Allow me a minute.
Okay, take your time.
Who are we talking about?
I don't know, but it won't be Mr. Harrison. You don't get to have your pick and choice. I will appoint some.
Not picking.
I don't know. I don't know who it will be. I don't make that job. The law does not allow this court to appoint a particular individual. They do not work for the court. I only appoint, and then the system, the Indigent Defense Commission appoints an attorney based upon that attorney's availability. So if you say yes, you want an attorney appointed to assist you or to consult with, then I will sign a piece of paper that once again says they are to appoint an attorney. It won't be Mr. Harrison. Then that attorney will come and speak with you. And then you guys can begin to talk about a case. That attorney can consult with you in little ways or big ways. Meaning they can help you represent you and give you guidance, or they can represent you in the court as if they were the active attorney. But then the public defender, the public defender system will appoint that attorney.
Now I
So all I need to know is
Yes.
if you want somebody. Okay,
Yes.
that's all I needed to know.
Misunderstood the way you explained it there. I understood.
Okay, all right. The court will once again appoint an attorney, consult with, and then we will have our final pretrial conference next Friday. Either you or that attorney can file motions. The court will still entertain them, even if we are past the due date. I think the law would require me to extend those deadlines because there would be good cause. The good cause is based upon the defendant's trying to represent himself, some confusion with instructions from the court. And we will be back here next Friday. I will now take the next step to get counsel appointed to assist you. That's all we needed to know. Now that attorney could come to me and tell me, hey, Judge, he doesn't want us. And then we will take care of that when that happens. I just need to let you know, the court does not have a long list of attorneys to give you. All I do is refer my appointment. All I do is make a referral, and then they assign an attorney to you. Okay?
Can I have one question?
Yes, sir. Of course.
Then if I've sent Mr. Wiggins the names of witnesses that I wanted subpoenaed, is he going to give me discovery and put these witnesses on the list? Because there's certain that haven't been added to the list.
Okay. Here's the next question. Here's an answer to that question. The prosecutor is not responsible for bringing your witnesses. The prosecutor is responsible to tell you who are what are called re justi witnesses, in other words, like eyewitnesses, and he's responsible for subpoenaing the witnesses he chooses to call. Now, when you go to call a witness, or the defense goes to call a witness, the defense issues its own subpoenas, which can be signed by the court, and the court will order those witnesses. So, in every case, Each side, meaning the prosecutor and the defense, submit their own witness lists to the court clerk, who will then provide me those copies. No one outside of the defense is required to get defense witnesses. That is entirely done by the defense team. If they're having problem getting those witnesses, then they can ask the court to order a subpoena to compel them to appear. So by sending Mr. Wiggins a list of witnesses, all you're doing is telling him who you intend to call. He doesn't have any obligation to him.
Based on what you just told me, it is Mr. Wiggins that has to call him because the EMTs were there with the police, and if the police arrest Gastay and the witnesses, then the EMTs or the paramedics that were on scene are certainly, because the police interviewed them and they didn't state the interviews in the police report or the contents of the interviews, and I think that that's going to be crucial. And those are Ross Gastay. If the police are Ross Gastay, they're all on scene.
Maybe I misstated it, or maybe it was miscommunicated. The prosecutor must list out for you 2 lists. 1, list the Ray Gastay witnesses. 2, list the witnesses he intends to call. He's not in charge of bringing defense witnesses.
Well,
that's a defense job.
Yeah, that's every witness that came after the fact that's been mentioned. Every witness that he has on that list came after the fact. They came to the scene. I don't see the difference between the EMTs and the police and the people that pulled up behind me. They all showed up after the fact. But they were all at the scene in a group.
Right.
To pick and choose to say that he only has to call this witness or that witness is because I feel like he needs to bring him.
Thank you, Officer Patton. Officer Patton, I'll wrap it up here right now. The court will refer the matter for appointment of an attorney to consult with Mr. Burns. I find that his request to represent himself was not unequivocal because it appears he still wants some assistance. Therefore, the court denies the request to self-represent, but will look for an attorney to help him as a consultant. Thank you. We are